back from lunch. I am pleased to be sort of organizing this panel, claiming the right of peaceful assembly. The capacity for assembly and protest to serve its various political and democratic functions that we talked about this morning does, I think, depend to some degree, at least, on the existence of the right, even if the right shouldn't cannibalize the whole conception of assembly. And so, by which I mean it depends on how authorities interpret both the scope of the right and what we determine are permissible limitations on that right, given the interests of the broader public. So if we think about outdoor assemblies, consistently salient issues which already came up in the morning are how do we define peaceful, as in within the right, as opposed to not peaceful, as in outside of the right, and is the opposite of peaceful violent, as plain English might suggest, or something else, and even if it's violent, what's the threshold? And I'm sure we'll talk about all those things. And similarly, at what point should the disruption caused by an otherwise protected assembly become justifications for its management or even dispersal? Maybe even, if we think even pushing the frame backwards or flipping the frame. Another area I think that's constantly, not constantly, but of contention is when might repeated engagement in unprotected protests or assemblies justify banning support or membership of the group that organizes it or allegedly does so. So these are the line drawing issues that I think our panel is going to be talking about. I think they only get more difficult when we think beyond the sort of proverbial public square to digital or online assemblies. And I'm delighted to have this wonderful panel to discuss these issues with us. So they are going to shed some light on these questions and also share what in their views are the most concerning gaps in protection. Like in the first panel, there was very little optimism. I said, share what you think the strengths are. And I got a lot of like, maybe we'll share our concerns. So we'll leave it to the audience to maybe bring in some optimism. So anyways, without further ado, Dr. Orsolya Salát is an associate professor in human rights and comparative constitutional law at El-Haj, University in Budapest, and the National Director of the European Master's Program in Human Rights and Democratization there. She is the author of a wonderful monograph on comparative freedom of assembly law, and like everyone else, also the author of several articles and chapters in relation to similar themes. David Mead is a professor of UK human rights law at the University of East Anglia, and the author of the leading case book on peaceful actually it's not a case book, it's a UK book on, I don't know that it's a case book, UK book on peaceful protest. He, in recent years, in 2021-22, was the academic fellow to the Joint Committee on Human Rights at the time that the Police Crime Sentencing and Courts Act was making its way through Westminster. And then we have Kirsty Hughes from Cambridge, Associate Professor of Law at the University of Cambridge and Director of the Center of Public Law. She's the author of Human Rights Law in the UK and a General Editor at the European Human Rights Law Review. And we are really delighted to hear from them, and also are, like in our first panel, going to give a lot of space because we really have amassed an excellent group of participants who have enormous expertise here. So, turn it over to you.
Okay, so I start.
Yes.
Okay, so thank you very much for everyone. It's really an honor to be here. I try to be quick and systematic, first of all, because I don't know whether like I have so much novel, like real new developments to say, but I think it's important that we make progress on the systematization of this, right? So in principle, I have 3 points to make. The first one is kind of bird's eye view look at the peacefulness requirement from the perspective of basically general fundamental rights theory. The second is to look at it from the angle of other, as the Germans would call, like communicative freedoms, or I tend to call them lately rights of the public sphere. And the third is from the angle of the relation between general freedom of expression and freedom of assembly. So suppose kind of same debates we had a little bit through these layers. So firstly, as to like kind of generally, if one exercises a fundamental right in a way that goes beyond the permissible scope of that right, then what happens? One faces legal consequences, civil, administrative, or criminal, yes, sanctions. But we also know that the ideas of the rule of law and simply the sheer idea of having a fundamental right, by definition, includes that such sanctions are not to be inflicted by the executive power alone, surely not alone, but in a due process of law, ultimately under the control of independent courts. However, as you all know, that's not the case with assemblies, which are judged by the police or other assembly authority to be or to become unpeaceful, because they may be banned in advance or dispersed on the spot by violence. Therefore, unpeacefulness is a criterion which allows not for sanctioning the overstepping of justified limits of a right in a due process of law, but preventing or stopping the exercise of a right altogether. This is problematic since it allows for a deprivation, even if a court later finds that the conditions for deprivation were not fulfilled, or if police simply or prosecution does not pursue the case in front of a court. Therefore, I claim that the functioning of the peacefulness requirement questions the status of freedom of assembly as a fundamental right. Secondly, such executive restraint, which in our case often is a prior restraint, is unheard of in other areas of quintessential democratic freedoms, especially, freedom of expressive rights. And I claim it is because in freedom of speech theory, the preferred form of expression is discursive, and is focused on monitoring, controlling, correcting the representative governance. The theory through which courts and legislators, and even some scholars, consciously or unconsciously, look at freedom of assembly is basically still that of Alexander Macleod. What is important is not that everybody talks, but that everything what is important is to be said. This is a distorted view of democracy, which makes popular expression and assemblies subservient to the interest of representative governance and its institutions. Okay, still, we see that some courts, such as the ECHR, or in principle, the German Federal Constitutional Court, are trying to limit the threat posed by by a mistakenly imposed unpeacefulness criterion. However, you know that, systematic, whatever. However, I claim that parallel to the narrowing of the peacefulness requirement, they allow the introduction of ever newer categories which de facto function as unpeacefulness because they have the same consequence. Thirdly, this de facto replacement of the peacefulness requirement happens through an undue transposition of the limits of general freedom of expression to freedom of assembly. Basically, every activity which the legislator of the day puts in the criminal code, public order legislation, anti-terrorism legislation, you name it, may be used to justify banning an assembly in advance or disperse it. What a speaker says or would say on a demonstration gets treated much worse than if it was in an article, my example. It is used to annul the exercise of freedom of assembly by an indefinite number of others. I think it is important to emphasize very clearly and over again that both the laws and the judicial doctrine are structured in a way which result in banning people from exercising their right to freedom of assembly because there may be a speaker engaging in illegal expression. And the categories of such potential would-be illegal expression are increasing as we talk. Many of those laws are often extremely vague. You know, in the UK, you still have provisions limiting expression which causes anger, and have absolutely nothing to do with violence against persons, which is the common sense meaning for unpeacefulness. In addition, laws which claim to be justified limits on freedom of expression and are as such used to ban assemblies are often not only content-based but also viewpoint discriminatory. Just check out the new German bill on denying Israel's right to exist. Instead of arresting the speaker and condemning the speaker in a due process of law, as if it was an article in a newspaper, what we see is that the exercise of another right of others who never engaged in illegal expression is made impossible. While sometimes courts stand up against such reasoning, again, one German example would be the Berlin Administrative Court as to the Palestina Congress 2 years ago. But there is no automatic decoupling in the doctrine of freedom of expression and freedom of assembly. Therefore, while I consider the narrowing of the peacefulness requirement a welcome development in some parts of the jurisdiction, I find it hypocritical and half-hearted, as it comes with widening the possibility of advancements and dispersals as a revenge for what a speaker says or may say in the future on a demonstration. Thank you.
I'm a notoriously poor timekeeper, both in academic life and in my own personal life. So I've had to put this up, which I'll obviously just ignore, but at least we can all pretend, can't we? I'm going to try and do three things, developing a little bit from what Orsolya just said in the talk. One, a bit, apologies, I'm a dull trial lawyer, some dull doctrine, and then some fun socio-legal stuff. Which I've sort of got into in the last few years. So the three things are a little bit of a trawl through ECHR case law on what peacefulness means, or rather what sorts of issues arise when courts are confronted with protests. And then secondly, trying to reclaim the value of disruptive protests, which is what the chapter in the handbook is about. And thirdly, if I have time, brackets I won't, but let's assume I do, looking at how disruption has been used by state institutions as a means to crack down on protests domestically. So the first then is, and apologies, this is sort of UK Eurocentric to the mixed room. So some will be possibly be very familiar, but apologies for that. Richard Martin, in a recent piece in Public Law, we have just put out a really, really splendid special issue, and Richard, in his chapter, tried to demarcate different typologies of where the court should and has and hasn't stepped in. And that set me thinking when I was preparing this over the weekend, and I've come up with 8. Richard only came up with 3, so I'm better, obviously. I've come up with about 8 different gradations, some of which are overlapping, so there aren't really 8. The first is where Article 11 just doesn't arise at all. I know we were talking about some of this earlier in the gaps and overlaps between free speech association and assembly. But I'm thinking either things that aren't assemblies, so 1 or 2 person protests like in Faber and Tabatha against Hungary, or where somebody is arrested purely for the content of their placard. It's very hard to think how those will raise assembly issues, and thus we're looking at article in UK terms in Article 10. But where there are a lot of people coming together collectively to make their point, we are likelier to be looking at Article 11. And Article 11, as Orsolya said, is premised on peaceful assemblies. So we need to unpack what that means. And it's important because if an assembly is not peaceful, we never get, in UK and European terms, to proportionality. It's defined out. So the state never needs to justify anything for what it's done. So we learn certainly that peacefulness is the antithesis of violence. So using violence, threatening violence, inciting violence, and being violent. So if you are any of those, your protest becomes a non-peaceful one. just parking for very slightly an issue, an old friend of mine, an old favourite of mine, the difference between a protest being unpeaceful and protesters being unpeaceful. And it's really important. Courts blur this, police blur this, but it's really important conceptually that we are talking about protesters having a right rather than the protest itself having any sort of rights at all. So we have violence, but we also have a couple of other things that will indicate that the protest is not peaceful. So question one, does this include violence to property? We might come back and explore that. There's been discussion in the UK courts, no real conclusions reached, but we can perhaps float that. And then another area where the courts have ruled out is otherwise deny the foundations of democratic society. And there has not been an awful lot of case law on that. And it intrigues me because on one hand, all forms of, or many forms of direct action are rejecting the premises of democratic society, since they are trying to change things without going through democratic processes. That's never been... I'm sorry, I'm not arguing. I'm not sort of coming up with a... That's a bad argument. I'm just floating it as a thing. But the case law that exists takes a very narrow view to that sort of a thing. So then we have got on to assemblies that are peaceful. And we've got various levels of disruption that the court effectively gives increasing degrees of appreciation, deference to state institutions. So states are meant to give a lot of tolerance towards protests that are where the side effect, disruption is the side effect. That just happens when you have large numbers of people on the ground. But increasingly, the state is much more able to impose repressive measures where either it's an unauthorised but disruptive protest or where the disruption is intentional. This is where we get to the discussion in Kudrevicius about what is the core and not at the core. And we then also have, in Kudrevicius, some interesting words that there might even be some things that are outside the core of protection in entirety. But given that in Kudrevicius they blockaded 3 major roads for 3 days, and the court there still said this is within, but it would be most measures are going to be proportionate, I think we would probably be hard put. The court has not had to confront that sort of definitional problem yet, but may doubt do so. So that's the claim about disruption at a doctrinal level. Briefly, because I have just looked at the clock and I'm just atrocious. 2 claims I want to sort of suggest. One is to restake the value of disruptive protest. Doctrinally, the court allows it, and I think it is really important that we reclaim this. In a chapter that I had out a few weeks ago, I have tried to reclaim the need for a disruptive protest as an agonistic necessity. We need to be jolted out of our complacency if we are to try and reach any sort of change. And then the second, which will be familiar to a few people in the room, is my old trope about good disruption and bad disruption. So I don't think when the courts are worried about disruption, they are worried about disruption. Because if they were worried about disruption, states would legitimise police, etc., to stop all sorts of disruption. But they are not. They are authorised to stop politically participative disruption, usually in collective shows of strength. And the example I have been using, and I know some in this room will be very, very bored of this, I know, because they read it in almost everything I've been writing the last couple of years. There is a difference between a large group of people walking down Oxford Street trying to go shopping. The police simply would not stop that and probably would not have the power to. But if any of those groups of people decided they wanted to take on global capitalism and prevent people going shopping, they would soon be stopped by the police. So the same people, the same number of people, they probably wouldn't be the same people. It'd be very sort of yin and yang to the approach to shopping, but they would be stopped. So it is not disruption per se that's the problem. It's politically participative disruption that threatens the social order. That's what states are worried about, and that's what courts need to worry about a lot more.
Okay. Well, thank you. So in my brief intervention, I'm going to talk about the Palestine Action case. And I know this is a very mixed audience, both jurisdictionally and discipline-wise. So I'll try and pitch it that it's accessible for everyone. So I'm going to talk about what the High Court decision was, why it found prescription to be unlawful, why this may be overturned on appeal, and just to highlight some considerations going forward. So as I'm sure everyone is aware, Palestine Action was prescribed as a terrorist organization in July 2025. And since then, thousands of peaceful protesters have been arrested for displaying signs indicating support for Palestine Action. And the prescription of Palestine Action has been challenged by way of judicial review. In February, the High Court held that prescription was unlawful on 2 grounds. This has been appealed. The Court of Appeal hearing took place on the 28th and 29th of April. So we await its judgment, and Palestine Action remains prescribed pending the appeal. So dealing first then with the High Court judgment, the first point I think to observe is that while the High Court found prescription unlawful, it rejected the argument that the actions of Palestine Action are consistent with the concept of civil disobedience. It stated that the core hallmarks of civil disobedience are the objective of seeking a change in the law or government policy, an approach of law breaking that's characterized by restraint, and acceptance of the legal consequences of one's actions. And it then went on to declare that these are emphatically not the hallmarks of Palestine Action's campaign. It also observed that there'd been 3 incidents of serious damage to property prior to prescription, and that there was a lack of evidence as to the nature of Palestine Action as an organization from which the court could then conclude that those events were outliers. And consequently, the High Court held that the argument that Palestine Action is a non-violent organization was unsustainable. So that might have seemed fairly fatal to the challenge, but the court nevertheless found prescription unlawful for 2 reasons. So the first was that the decision was made by the Home Secretary in breach of her own policy. So she'd taken into account a factor that was not specified in the policy. The court took the view that as the policy was intended to limit the Secretary's discretion, that taking that into account was an additional factor that was not consistent with that policy, or not consistent with the purpose of that policy. The court also held that the decision to prescribe was contrary to the Human Rights Act because it amounted to an unjustified interference with Articles 10 and 11 of the European Convention on Human Rights. So Article 10 is freedom of expression, 11, association and assembly. And in relation to the human rights argument, there were 2 issues. The first was that the policy, by not being properly applied, meant that the measure was not in accordance with law. So there was a legality issue. And then second, that the interference was disproportionate. And here the court observed that Palestine Action had undertaken activities amounting to terrorism, and that it, therefore the court, had to give weight to the opinion of the Home Secretary, but nevertheless prescription was disproportionate, as only a very small number of Palestine Action's activities amounted to acts of terrorism. And so it held that the nature and scale of the activities had therefore not yet reached the level, the scale and persistence, to warrant prescription. So that brings us then to the appeal. I should probably add, by the way, that I'm not in any way involved in the proceedings, and I'm focusing very much on a doctrinal interpretation. So the government in the appeal is arguing that the High Court erred in finding that the Home Secretary breached her own policy. It's also arguing that the High Court erred in determining that the ban constituted an unjustified interference with the Convention rights. Now, in relation to the policy argument, the government's arguing that it doesn't act as a straitjacket, that it's guidance, but it doesn't constrain the discretion in this way. It didn't exclude the consideration of these factors. There's been discussion about the status of the document as well. And they may well succeed in challenging the policy interpretation from the High Court. In respect of human rights, the government continues to argue that Article 17 applies and that it precludes the application of Articles 10 and 11. This is contested by Palestine Action, who point to the fact that there's no ECHR case law indicating that Article 17 applies to property damage. A point that doesn't seem to have been discussed as far as I'm aware, and probably maybe because it doesn't advance the claim of either party, is that even where Article 17 does apply, so Article 17 precludes relying on convention rights in certain circumstances, that what the European Court of Human Rights often does is it doesn't exclude those rights altogether, but in fact runs the two in tandem. So it will give an Article 17 interpretation to the application of the convention rights. The critical question, though, which seems to be the case in the appeal, is whether it was a proportionate interference. And here I think there are several difficulties for Palestine Action. First, if we return to the tenor of the High Court judgment, that strongly suggests, in terms of its factual assessment of Palestine Action, that perhaps the interference was proportionate, especially as there's nothing necessarily to say that from the European Court of Human Rights that states have to really wait and wait and wait before intervening. I think in the proportionality assessment, the difficulty from the High Court judgment is that it focuses on this sense of the scale of the activities rather than the availability of other measures as an alternative to prescription, which maybe would have been more helpful in that respect. Second, and I think these two things combine, is the dicta that we've seen from the UK Supreme Court in a number of recent judgments, which points to considerable deference to the executive on security issues, and that's being strongly pointed to in the appeal by the government, and essentially arguing that the High Court hasn't respected the institutional and democratic competence of the Secretary of State. So those two things together could be problematic for Palestine Action. What then does the Palestine Action case show us? So I think there's a few points maybe to think about in terms of the discussion. First, the limits on Palestine Action as a sort of ideal test case for making the arguments in terms of challenging both the parameters and application of these provisions. In fact, the breadth of the definition and the application of the definition are not being challenged at all. Second, that this is probably very much representative of the reality and the complexity of attaching single labels of the type that we've mentioned already, so peaceful, non-peaceful, violent, non-violent, protest, terrorist, to what is an organic and unwieldy social movement. And third is thinking about what the Palestine Action case might mean for the concept of civil disobedience. If we recall that the High Court stated that the hallmarks of civil disobedience are characterized by restraint, acceptance of the legal consequences, then I think there are two issues to consider. First, that while the High Court determined that that was not the hallmarks of Palestine Action as an organization, that definition of civil disobedience does match squarely onto protesters that have been arrested since prescription for holding signs expressing support for Palestine Action. The second point to consider is what it suggests about the foundations of the concept of civil disobedience. If we examine the earlier case law that the court was citing, it referred to eschewing violence and showing some measure of moderation in the level of harm intended. But in some cases, and in Palestine Action case itself, we see references to showing restraint, proportionality, I'm almost done, and whether this was limited to merely symbolic acts. And so that raises questions, therefore, as to whether the parameters of the concept of civil disobedience are being further and further curtailed. Thank you.
Thank you, Kirsty, for that. And actually, since it's fresh in our mind, I guess I want to start in the inverse of what we planned, which is to ask David or Orsolya if you have reactions to that. As an American, I have lots of reactions to this, but I'm going to not share my reactions. I'm going to let you respond, if you would like, to the Palestine Action case, to Kirsty's analysis, which I thought was very helpful to me to understand either of you. David, do you want to start?
Yeah, happy to. I ought to declare for purposes of candour that I am a witness in the Palestine Action case on the part of Palestine Action. So I'm involved in the case in a peripheral way. And the evidence I gave sort of goes a little bit to one of the points that you were discussing, which did surprise me about the case, which is the disproportionality in that the evidence I gave was that this, as many in the room know, this is the first time that this group has been targeted, but I was able to document with a degree of authority that previous groups that had undertaken, I mean, not the same sorts of acts, but acts that had quite high levels of economic damage, had not been so treated. So I suppose I'm wondering whether there is a question coming as to whether you think something like that might feature, or do you think it's obviated by the fact that it was really not in the minds of the High Court? In other words, the Court of Appeal is only going to be able to decide stuff that is appealable rather than that it goes to the proportionality and other measures that could have been taken, I suppose. And I suppose it's a question whether there's anything you want to expand upon that. Sorry, that wasn't really a question at all.
Just quickly, so what I don't understand, but I'm really not in this area, but I don't, to be honest, so is it, okay, you cause damage, and then why don't they make you pay for the damage, you know? So I just, to be honest, I don't understand. So this whole logic that whatever you want to do with anti-terrorism, you can do it, right? And then you just ban, okay? And I know it's not only in the UK, it's everywhere, yeah? It functions like that. So that you get all these thresholds, yeah? That when you're in that group, yeah, then it's over, yeah? So I don't know, right? But because we sometimes have these discussions in the First Amendment law that sometimes punitive damages are worse than whatever deprivation of liberty or have bigger of a chilling effect. But how, since when do we have that? Yeah, in I don't know, in Western law, or where do we have it? I don't know. Yeah, that kind of, so okay, criminal, yeah, damage, pay for it, but no, it's a proscription, right? And then it's a cascade. Okay, that you cannot support it, and then, so that it's not. Anyway, so what do you think about? Yeah.
So I think they're slightly different things, but I think we can maybe bring some of them together. So one is really a policy stance or normative stance, which I think is what you're saying. So why have these prior restraints at all? I think is effectively what you're saying, instead of just dealing with it after the event, which I think also very much ties in with what David's saying, and saying that, you know, there's a whole raft of other legal provisions there which are applicable. Why don't we just use those instead? Those have been used in relation to other organizations. Why not use them in relation to Palestine Action? And I wouldn't disagree with that. Mm-hmm. Like, I don't disagree with that normatively speaking. Okay, the question is about how the arguments have been set up in this particular case, and that what we're not doing is we're not actually saying, okay, should there be this breadth of power to prescribe organizations under the Terrorism Act, and therefore that in itself is incompatible. It's been accepted that definition is met in this case, mm-hmm. And then the question is about whether then the prescription power should have been exercised in accordance to it. So we could argue, okay, well, actually, you shouldn't have within the terrorism definition anything which includes organizations where you can be prescribed purely on the basis of serious damage to property, that you should just focus on violence, for example. That would be one way. But then in terms of the proportionality assessment, like you, I would agree that you would want to see in the analysis of the court more discussion about, okay, well, what about all the other measures, you know, bearing in mind that it's supposed to be proportionate, it's supposed to have least restrictive means. why aren't those being used instead? But I don't think that was really the focus in the High Court judgment.
Or you could have the prior question, which is, should you be able to ban the organization? Not just did they meet it, but I think that's what you were saying, is should you be able to ban the organization at all, even if they were a terrorist organization? Like, whether that would be constitutional, or you're saying that, or whether that would be a violation of the European Court of Human Rights.
Yeah, so then you'd be having a different challenge, which would be
Right.
to say that we're saying that the legislative regime in itself is incompatible.
Right. This is, yeah. Let's not get down this rabbit hole, which seems like a rabbit hole. And actually now, Kirsty, I would like to give you an opportunity to respond. Both of them in different ways talked about existing regimes, Orsolya from a more normative perspective, David laying out some of the UK law. Is there anything that you wanted to react to or draw out before we move to the audience? And I actually have a question in between that transition.
Yeah, so I think one of the things that I find interesting, which runs across both of the presentations, is the parameters of peaceful and then where it lies in relation to disruption. And I thought, David, you might have some thoughts on the direction of travel in respect of that in the UK, where we had this judgment in Ziegler, but then we've seen the courts really reining back in from Ziegler, and now provisions on cumulative disruption. So I wondered if you wanted to add anything, I guess.
That was the third. That's as if we've practiced this. That was the third thing that I ran out of time for. So I think what we're seeing in the UK, and I'd be very interested whether other jurisdictions and or internationally this applies too, is we're seeing the sort of the contortion of disruption, because we're seeing disruption being enlisted in the service of restriction. So serious so for those that know, the UK a couple of weeks ago passed an act, one of which powers allows the police to impose conditions on processions and assemblies because of cumulative disruption in the past caused perhaps by a totally different group. So you are being potentially being tainted by another group's disruption. But I think perhaps the most pertinent point, which perhaps deals with that, is the, again, apologies to those in the room who are familiar with this, the English definition of disruption, or serious disruption, is farcical in that for certain offences you have committed serious disruption to someone else if you do something that causes more than minor disruption to them. I don't think we have to be the lexicographer general to realise that there is a big gap between serious and more than minor. But that's the view that English law has taken. So I think I can't see it ending other than badly, insofar as disruption is now being used, both in discourse and political discourse around restrictions, and legally in documents to impose restrictions on disruption. So the argument that I was trying to make that we should reclaim disruption, is clearly never going to get off the ground in the UK, because the movement is to stop disruption rather than to celebrate it.
Oh, I couldn't have gotten a better invitation to what I wanted to say, which is, I think it was as if we did, right? No, so, one of the things that this conversation highlights for me is just how all the conversations about the right of assembly end up being about disruption or about violence, and very little really about the value of assembly itself. And I think in Orsolya, in your comments, it was, you sort of ran over it quickly, but the way I think of it is assembly is sort of suffers under the long shadow, or maybe it's just a dark shadow that freedom of expression casts. So in the disruptive elements of assembly, especially when it's protests, are salient. No, you don't need to be far right or a police officer to understand that these events can be highly disruptive, right? But it turns out, I think, that when push comes to shove, everyone is struggling to articulate what the actual value is. And so the default rule is, well, and David, even you said it, you said they have a point to make about capitalism, right? Is this expressive version, which is the assembly is valuable because it expresses something, it has a point to make, or that it's somehow instrumentally political valuable. But I think both of those values really fall pretty quickly because actually there are many other ways to make your point that are less disruptive. And actually most assemblies are not that instrumentally effective. So it's sort of, you've set it up in a way that, and so I guess that's one of the things I thought maybe I would invite you to react to in the audience is, sort of assembly might look different if we did think about it as a distinct form of politics, as a social form of politics, if we were more thinking about the social solidarity effects, about sort of the politics of presence. What does it mean for an organization like Palestine Action to say, we're here too, right? We have these perspectives, and we're part of your community. England, like the U.S., has changed radically in terms of how diverse it is as a society over the last 50 years, or at least people are noticing it more. And then with respect to disruption, I always think, well, the true threat is actually what you sort of set up earlier, David, which is that this social form of politics, it can lead to the Boston Tea Party, or the Iranians were clearly repressing their protests because they were afraid it would lead to the fall of the regime, or in the South in the 1960s, the end of Jim Crow, right? It doesn't happen that often, but it's not actually the threat of violence, it's the threat of political disruption. And I just think it's really sort of interesting to think about the way in which we talk about assembly always about its inconvenience and disruption and potential risk for violence, and very little about how to think about why we protect it at all, or only in these secondary ways. So I didn't know if people wanted to react to that. Or
Okay, I'm still thinking about that. I know that you are saying that it is not to be focused, to be on expression, and I have a sense that surely it's not to be focused on discursive, propositional, yeah. But I'm not sure that we can let go expression, or that we are saying that expression in the sense like you have in freedom of religion, or like forum externum, that would be a legitimate aspect for the state to regulate if it does it in a way that conforms to fundamental rights standards. So that's why I think there is this confusion actually about the relation of assembly and expression, because these are like the two-edged sword, or how we say it, right? So everyone is a native speaker, but yes, that's the trick. And and I don't mean by it in any way to say that assembly does not have those values which you claim it has, but the state has even less of legitimacy to regulate somehow those values, than it has to the expression of those values, something like that. I'm trying to, but then still, that's why I'm coming up with Michael. That's actually just Michael Jones, something just exactly to, but I'm not sure.
I can say something.
Yeah.
So, I agree with you. I think, in general, I would say certainly in the assembly case law, we do seem to see assembly conceptualized, to the extent it's conceptualized at all, as its values being sort of coexisting with freedom of expression. And I would agree that there is a need to have a more associational values component to that. I don't think that's necessarily unique to freedom of assembly. I think there's other convention rights where there's also less of a exploration of their underlying values. Freedom of expression is very well supported in that sense. But I mean, some of my work was in the right to privacy. We see similar issues there, and also a very kind of individualistic focus rather than a social focus. But in terms of Palestine Action, I don't think that really is the issue, because in Palestine Action, I think the associational component is really very much at the fore. So I don't think you necessarily have quite the same issue in that particular context.
So I started with the lovely job of being able to start it, but now I have the terrible job of having to say we are done, although there were many people who I did not get to in the queue, and I look forward to other conversations later this afternoon. Thank you.